Hello, everyone. It's Yoli Medina, and I've been following the Kohberger case. So I do want to give you all my impressions on the hearings that took place last week on the motions to suppress evidence in the Kohberger case and the motion to compel expert witness information that was filed by the defense to compel the prosecution's expert witness information. So first, with regards to the hearings, I should say, I just want everybody to appreciate how difficult it was for these attorneys to argue the particular issues in this case. After I thought about it, the first part of the hearing on the first day was closed to the public, and that was the evidence portion of the IGG regarding the suppression of the IGG, which is investigative genetic genealogy. It's a handful. So there was witness testimony about that, along with other testimonies regarding the case. The public didn't get to see that. And so what the public did get to see was the argument. You argue the law and the facts, right, in the motion to suppress. And so what the public did get to see was the legal argument. But here's the issue. I put myself in the situation of these attorneys, and basically they're like arguing with their hands tied behind their back. And the reason why I say that is because they're arguing facts that are sealed. So they have to be careful with what they say. So some material that was sealed seeped out, things that we didn't know before the hearing. For example, one of the things that seeped out was that there was blood on a handrail on a staircase of an unknown male. So there was actually blood, not skin cells, but blood. And when you think of that in comparison to the skin cells that were found on the knife sheath, on the button snap of the knife sheath, you think, well, wow, would a judge that was going to sign a search warrant or an arrest warrant, would a judge want to know that information, that there was unknown DNA on a handrail? An unknown male DNA of blood on a handrail? Well, I don't know. But then there was also information that there was blood found on a glove outside of the area of the home. Now, we knew there was a glove that was found, but we didn't know that there was a bloody glove. That seeped out. What also seeped out was information on the interview with DM, who was one of the witnesses who was in the house and who allegedly in the probable cause affidavit by Brett Payne said that she saw a man clad in black, 5'10" to 6 feet, with a mask and bushy eyebrows, walking in the hallway and heading toward the kitchen, heading out. So we learned information that, and well, not only did we learn information, but we learned that there's a statement that actually has a page and line to it where DM said, she didn't know if it was a dream. She wasn't sure. She was interviewed 3 times. And these things we didn't know before. And they had to be talked about in this hearing, because what the judge did, and I'm sure he's trying to balance the interests of having, things sealed and having things public. And it's a very strange case. And so what I'm trying to say is, it was very, very difficult for these attorneys to argue this. I could see it. I mean, maybe not right away, but in thinking about it, wow, you know, you're having to argue stuff that is sealed, but you want to analogize the law to the facts, and it's impossible. I mean, come on. Some of that stuff is going to come out. It's impossible. So they were in a very difficult situation. And I don't think it was intentional. I think that the judge is trying to make the best decisions, and so be it. But we learned a couple of things about the case that we didn't know. And so for anybody to say that they know that Bryan Kohberger committed the crime, well, that may be their opinion, but we don't really know. We don't know. There are facts that are still under seal that we don't know. And one thing I touched upon, well, one thing that I listened to was when Brett Payne was on his way to Pennsylvania to Bryan Kohberger's home or family home where he went for spring break. And Brett Payne was looking at a live feed of a drone that was watching Bryan Kohberger as he moved along in the house. At least that's what I understood. And then you have all this SWAT team outside of his home in Pennsylvania, family home. And it seems like this super crazy, almost like CIA type of operation where Bryan Kohberger is a suspect of very dangerous crimes. And no doubt that what happened to these 4 students was awful. But it took it to another level. I mean, if they did admit that they were surveilling Bryan Kohberger, this is the FBI, and that he was jogging around his house, jogging in the area. And, they could have arrested him when he was jogging. Like, you don't need all this drama, like the SWAT team coming in. And the other thing is, the judge, who's a good judge, he's challenging both sides, but he has to challenge the defense more so because the defense is the one who brought these motions to suppress this evidence. And so they have the burden. The defense in this case has the burden to show why these types of materials that were gathered in the investigation need to be suppressed and kept out of the trial. So the judge was challenging, was challenging the attorneys during the oral arguments. And what's interesting is when Jay Logston came, he was one of the male attorneys that argued, and he argued with regard to the arrest and the search warrant in the house. And, he talked about how the SWAT team, they had a sniper that had like a red dot on Kohberger where he was moving around the house. I don't know, that I've seen too many movies where there's like secret undercover stuff, and it just reminds me of that. Like, what could Kohberger, like, what more was going on here other than the unaliving of the 4 students? I don't know. I really don't. Nobody knows. But Brett Payne was on his way there, and he was looking at a live feed of a drone while they were surveilling Bryan Kohberger. We didn't know that. So, it brings me to the point where the judge said something like, well, he was challenging the attorney, and he said, well, they did the arrest the way they did, like with the SWAT team and no knock warrant, because of destruction of evidence and the safety of the officers. Well, when they arrested, or when they were doing this was over a month after the crime had occurred. So if he was trying to destroy evidence at this point, it seems a little unbelievable. You would think he would try to destroy evidence shortly after the crime, not a month and a half after the crime. And so when the judge pointed that out, I think it was when the prosecution, Bill Thompson, was arguing, and he mentioned something to the effect about the fugitive warrant. And I'm totally confused as to what it is that's going on, because as we've seen, part of it is sealed. A lot of the evidence is sealed, but it had to come out. It had to come out when the attorneys were arguing. I mean, there's no way you could argue the law and the facts without mentioning some of the evidence that was sealed. I mean, it's impossible. I mean, it was an impossible situation. It's like, I put myself in that situation. I think, okay, so I'm going to argue the law, and I'm going to argue why the evidence should be suppressed, and why the IgG, the investigative genetic genealogy, should be suppressed. But I can't mention the details in the argument because it's sealed. And now the public is listening to my argument, and I have to be careful with what I say. Well, that's like, in hindsight, that's, I don't know, it could be an appellate issue, because, as an attorney, you try to make a record on the record of, you argue things and you argue the facts. And so some of the facts seeped out. And even the judge, when they were talking about issues related to his arrest in Pennsylvania, the judge started to speak, and then he said, well, I don't want to go further because this is, like, the evidence isn't out there yet. It isn't out there. Like, and so when I think about it, I think it was a decision that was made by the judge. And I think in hindsight, it might not have been the best decision, but I don't know what other, I mean, I can't fault the judge for doing that. I think he's fair. I think he challenged both sides. I think he's really thinking about a Franks hearing. And let me tell you, I did not know what a Franks hearing was before this case. I will not lie. I knew about motions to suppress and motions in limine and the difference between those two. And so a motion to suppress is when you want to suppress evidence because the police officers or law enforcement didn't follow, or basically either negligently or intentionally violated the rights of a suspect, of a defendant. So you want to suppress any evidence that results from that, which is the fruit of the poisonous tree. I didn't know that there was such a thing as a Franks hearing. I mean, I learned that throughout this case, and I'm still learning. But based on what I see, I find this to be the most intriguing case legally and factually. And like, I think to myself, if I were in the position of the attorneys, both defense and prosecution, I would be, I don't know what I would do. I mean, maybe I would have said, well, because, Ann Taylor, the defense attorney, when the public hearing started on the first day, and he talked about the Franks hearing, she was like, I'm a little confused. She mentioned something like that. But, I think honestly, I think I would have said, well, Your Honor, you're having this hearing public, and we have to argue the law and the facts. And some of the facts are under seal. So how are we supposed to do this in a public hearing and make a record for appeal when we're half-ass arguing? We're arguing facts, but we have to be careful about what facts we state, because part of those facts are under seal. And I don't know. I think I would have said that because in my mind, I think I would have thought it through. But I'm just now realizing that that's what occurred, or in my mind, that's what occurred. And this is a novel case, I will say. I think a lot of people will say this is a novel case, and especially when it involves the investigatory genetic genealogy. And I put on my community post a video of an attorney, Steve Lato, I think it is, who talks about a Colorado Bureau of Investigative forensics person or lab person who is being criminally charged now for just mishandling intentionally and trying to make things according to what the prosecution wants with regards to DNA. And now, there's a lot of defendants who can challenge this because of her actions. So I'm going to put that video in the description box of this video. It's also on my community tab, and I urge everybody to look at it. It's very, very informative. And he's the attorney whose video it is. He said it. I can't say it any better. I mean, he said it. And this is something that we all need to be aware of, because I submitted my DNA to 23andMe. I've been open about that. And when I learned about how my DNA could be used and what I needed to do to prevent my DNA from being used in such a manner, I learned it through a witness that testified in a motion to compel in the Brian Kohberger case, and that was Gabriela Vargas. And a lot of people look, I'm an attorney. Do I read the fine print all the time? Not always. I'm probably the worst. But when it comes to something like this, if somebody gives some part of their body, their DNA, biological material, they should know how it's going to be used. I mean, there shouldn't be any fine print. There should be an alert, like red, that your DNA material can be used for, research and for the public in solving crimes. And yeah, my DNA was out there for research and whatever else. And so I had to opt out of those things, but I did not know that. Was it in a fine print somewhere when I sent my DNA? Probably, but if it's in a fine print, I mean, I don't know. Maybe it's my fault. Maybe it's the person who submits their DNA's fault, that they need to be more careful. Maybe I should be advocating that be careful, read the fine print. Maybe. But also these DNA companies who want to give people information about their background, they should also make it known. They should have it well established, alert. This is what you need to do. You need to opt out of these things if you don't want these things, if you don't want people to access your DNA. And so it's a very, very complicated issue. And I think Ann Taylor argued it as best as she could. And like I said, what we did learn also too was that Othram, this DNA lab, who allegedly wasn't accredited it just wasn't accredited. And in my past video, one of the past videos, I said, I don't know what that means for this case because previous law enforcement have used Othram. But what the record reflected when Ann Taylor was arguing was that Othram could not get a match, or could not get get the SNP to match some database. That was my understanding. It could be completely wrong, and I'm totally open to corrections. But in any event, the FBI took over and prepared what is a sample that allegedly matched a relative of Brian Kohberger. So what we also learned is that the FBI did not keep notes or anything like that. And I always say that what attorneys say is not evidence, and it isn't. So what we heard was arguments made by the attorney, Ann Taylor. How she characterized the evidence, I don't know if she characterized it accurately or not. But being put in a situation where you have to argue facts that are sealed in a public forum is a very difficult situation to be in. And I realize that. And, you know, the second hearing, there was a lot of issues with the exhibits. What exhibit is this? And the stickers and all that. And I know all of that. It's tedious. It's like, oh my God. And you want to have a book with all these exhibits labeled. In the real world, in a perfect world, you want to have all of that put together. You want to just go bam, bam, bam. But we're not in a perfect world. And I think the judge realized that, and the judge started identifying the exhibits for the record. And that was very kind of him to do that, because I would be frustrated. I'd be like, I would probably say, okay, we're gonna stop this hearing, and you're gonna go out and you're gonna get all the exhibits that you're gonna use to question this witness, and you're gonna put them in a book, and you're gonna give a copy to me, copy to the defense, to the prosecution, copy to the witness. And that's how we're gonna proceed. When you want to refer to an exhibit that's attached to one of the motions to suppress, it's gonna be in the book, labeled independently, and the witness is gonna have to turn to that exhibit so that it's identifiable for the record, because it's tedious and cumbersome. But you know what? This is a case where the whole world's watching. I mean, if the judge was very, very kind and helpful in moving things along, because we can criticize the attorneys all we want, but until you know what it's like to be in that situation. And this isn't a case where you're arguing for money, compensation. This is a case where you're arguing for somebody's life. And you have a client who's sitting there who looks, I mean, from the last hearing to this hearing, he looks just thin and frail. And, this is not to take away what the victims went through. Absolutely not. I mean, the victims went through hell. I wouldn't, the person needs to be punished to the full extent of the law, but we also have to look at the other side to make sure they got the right person. And I'm trying to give you some insight into what the defense attorneys are facing. And look, this is where I'm going to talk about the motion to compel, the expert's information. Now, in the motion to compel, it was said that there's no DNA expert report. Okay. And from what I understand, and from my experience, and I think from the judge's experience, Judge Hippler, these types of things are worked out. Okay. A lot of times you get your expert disclosures out because it's a deadline, and you do it quickly, and then opposing counsel tells you, hey, this isn't sufficient, and you supplement. Okay. Just like the judge said in the hearing, well, there's going to be supplements, and you work these things out. Okay. Now, what I do want to point out is that the defense, they hired experts like Cy Ray and others to give opinions based on information that law enforcement did to prosecute Brian Kohberger. And when I say law enforcement, it's broad, because we have Moscow, Idaho PD, we have Idaho State PD, and we have the FBI. So Cy Ray is going to look at what these people did and give an opinion. Okay. Now, the state may just use, for example, as an expert, the FBI agent who investigated a certain part of the case, like the cell phone towers or the digital evidence on the devices or the blood spatter or whatever it was that they did. Because Brett Payne, who's the officer, I guess lead detective, he really wasn't. I mean, you need a whole bunch of specialties to come together to work on this crime. And so when it comes to expert disclosures, some of these people who may have been in the chain of custody of handling certain evidence, they may have some expertise in handling the evidence, but that does not necessarily mean that they have a report as to how they handled the evidence. So when Judge Hippler said, I'm not gonna get involved in this, I'm not gonna compel the state to do anything, but he did issue a warning, and he said, look, if you want your evidence to come in, both sides, you need to make sure that you have disclosed what the expert is going to talk about. If the expert is simply going to talk about receiving of the evidence, of the biological evidence, the receipt of digital evidence, how it's handled, well, they may not have a report. They may have filled out some paperwork, they may have done certain things, but they're not necessarily going to have a whole written report. So when I say this, when people see this and there's no written report on the DNA, well, that's because the people who handled it in the chain of custody may not have a report. And so I understand what the judge is saying, and I expected the judge to do exactly what he did, is basically say, okay, your motion to compel the proper disclosures under the code is noted. The prosecution is on notice. They can supplement if they want. And if they don't, then we're going to have to deal with it at trial. And one thing he said is we don't want to be taking breaks to find out where in the record this was disclosed, because that would take up too much time. So please put whatever it is in your disclosures. And he kind of gave both parties a lesson, like, this is what you're supposed to do. And I think he's fair. I think he's totally fair. And I think the situation is a crazy situation. And in hindsight, maybe he might think, well, that may not have been fair to have them argue the law and the facts when most of the facts are under seal. Well, of course, that's why some of the information seeped out that we didn't know. It had to seep out because you can't argue the case without arguing the evidence. And if the evidence is sealed, you're in a conundrum. Like, how do you do that? And I think this is a learning experience for a lot of people. And I'm still learning. Like I said, I didn't know what a Franks hearing was before this case. I knew what a motion to suppress was, but I didn't know the specific name of the case. So I'm definitely not going to tout myself out as an expert in, how these motions are handled. But I will say this is a very unusual case. So there was an attorney who put out a video on a Colorado forensic person who is being charged criminally for handling of DNA. And so I'm going to put that in the description box. It's also my community post, and I urge all of you to review it. I'm not going to talk about it because the creator who talked about it did a perfect job. So in any event, those are my thoughts, and I'll talk to you guys on the next video.